Now, we've talked about waivers in the contract. We decided that in Virginia and in Pennsylvania, a waiver in your contract is unenforceable. It's as if it isn't even in there. So when you're reviewing those subcontracts people send you, you don't even need to cross that out. The General Assembly crossed it out for you. It's just not even there. It makes me a little bit nervous. In a way, I'd rather have you just cross it out and you can correctly tell people, well, it's unenforceable anyway. But if you're smart enough, if you can remember where the bridge is and where the river is and whether you're in DC or Maryland or Virginia, you're actually fine. You don't even have to worry about crossing it out. It's unenforceable in Virginia and Maryland. It is enforceable in DC. But the real point for our purposes now is that a waiver is effective. Even a waiver on future lien rights is effective after work has begun. You sign such waivers all the time after work has begun in Maryland and Virginia and DC. They are called progress payment waivers. And my main point to you this afternoon, if you did not know it already, is that progress payment waivers vary tremendously in how they're worded, and the result varies tremendously as a result. You have to, somebody in your company has to be able to read them, and it is English, it's not that complicated, but somebody in your company has to be able to read them, and somebody has to be able to strike them out. It's not that complicated, and it's like it's actually much simpler than the contracts. If you and I do it together 2 or 3 or 4 times, you're going to be able to do it just fine, but you got to make sure that somebody can do it. Here's a good example to start with. This is a true story. This was actually a case before the Supreme Court of Virginia, and this is the exact wording that is in a waiver that's used, ALTA it's called, the American Land Title Association, the association that all of the title companies or most of the title companies in the country belong to. It's like AIA contract. All the title companies have ALTA, and they have a bunch of forms, ALTA forms, and ALTA has a mechanics lien waiver form too. And a lot of people use it. And if it says Chicago Title at the top of a lien waiver somebody hands you, or it says American, First American Land Title, I'll bet you a donut that this is what it says in the body of that waiver. Now look at that. And you're smart enough to fill in the correct dollar amount that you're being paid, and you're smart enough to put today's date in there. Are you okay with that waiver? Are you ready to sign it? Why not? That's what's always killed me about asking this question. I give you the answer right on the slide. It's unusual for people to even notice that. It's the may now or hereafter have language. You just waived your lien rights for future deliveries. If you sign this waiver in exchange for the first $100 progress payment requisition you submit, and you supply $100,000 worth of labor and materials after this, you are an unsecured creditor throughout the rest of that project, because you waived any lien rights you may now or hereafter have in exchange for that first $100. That is what the Supreme Court of Virginia decided. I'm not sure I agree with that, but their grounds make some sense from a legal point of view. It's because third parties are relying on it. The bank is relying on your waiver. They would not allow any more bank draws unless they had this waiver. You have to notice now or hereafter, and you have to strike it. And there's also, we're going to go through 3 examples, it might be 4, and then I'm going to give you a few snippets you want to write on every waiver you ever sign. But here, you got to see that may now or hereafter. Now, I'm surprised nobody said, usually I get the comment at this point that, well, wait a minute, it says in consideration of this sum paid, I'm signing this waiver a week before I see the check. They want me to sign it and send it in, and I don't get the check for another week. Usually hands are waving on that. And that's a very intelligent, relevant comment, but I do, and you would rather say, it is better to say, in consideration of the sum of this many dollars, comma, upon receipt and clearance of these funds, you would rather do that. But as a matter of fact, I think you're okay anyway because of the legal doctrine of failure of consideration. If it says in consideration of, if you never receive the consideration, the contract's not enforceable. That's the significance of consideration, which is an old concept. You should learn to say upon receipt and clearance. But I think you're actually okay even if you don't. Okay, here's a new one. Here's what this one says. There's no now or hereafter language. Are you ready to sign this one? Nope. Your earlier comments, absolutely correct on this one. It says, in exchange for this fund, I'm releasing all lien rights I have for labor and materials supplied through today. What am I being paid for today? Am I being paid for all deliveries through November the 13th? Is that what today is? The 14th? Or am I getting paid for September invoices, or am I getting paid for October invoices? If I'm getting paid for September invoices, you need to cross out the word today and you need to say through September 30th, 2019. Fill in the correct date. Okay. How about this one? Dollar amount. This is kind of like the first one, except there's no now or hereafter language. And let's assume they put in the right date. We're paying you through September 30th. For all labor and materials supplied through September 30th. You okay with that? You ready to sign that one? Why not? Retention. How about retention? Isn't retention labor and materials supplied through September 30th? You just waived your lien rights to retention. What about change orders? Are they holding any change orders for the last 6 months and going to be holding them another 6 months? In that labor and materials you supplied through September 30th, 2019, you just waived your lien rights for change orders. So you want to say, this is what you do. After the 2019, you say, comma, except for retention and pending change orders. That's what you do. You say, upon receipt and clearance of funds, comma, except for retention and change orders. And you get the date right. That's what you do on every waiver you receive. So I would like for you guys, here's a really cool sentence, and this is a Fullertonism. I'm not aware of any case law on this, but I am pleased to give you, this is worth every penny you're paying for, this legal advice. It is my opinion that all of the problems we have talked about are solved if you put that sentence, and it's on the book, and right now, I didn't want to do this before, but if you go to chapter 2, it's at the end of chapter 2, because it's the same for every state lien rights, it's the same for bond rights, so I didn't put it in all those chapters. I put it at the end of chapter 2, which is contracts, because it's a type of contract. So go to page 2-46, and here's all the slides we just went through. Complete waiver in the middle of 46, waiver for retention, unpaid goods delivered, that's the date thing, change orders, make lien make lien waiver forms conditional. There's that sentence right there. This release will be effective only to the total dollar amount of payments received without any bankruptcy filing. So you're going to put that on every waiver you ever sign. Now, I would really much rather you be smart enough to say upon receipt and clearance of funds and say except for retention and change orders, because they will let you do that. And the waivers are a lot like contracts that, people will tell you, oh no, you're not allowed to change this. And it depends on how it's worded, but if this waiver has any of the problems we've been talking about, you could think about skipping the upon receipt and clearance of funds, because I think you're okay on that. But the retention and the change orders, it is patently unreasonable. The correct answer is bull. If somebody tells you you can't change it, the correct answer is that is bull. I tell you what, I'll go ahead and file my mechanics lien, and then I'll give you a release once your check clears. We can do it that way if you want. Sometimes, it's a sign of ignorance when people say that, but one thing you may have to do to solve that problem is let an escrow agent hold the money, like me. I put the money in my trust account and I'm not allowed to release it until I give the buyer your waiver of lien. There's various ways to solve it, but they ought to let you just change the waiver. You can put a period right after the word receive. That's the way my stamp used to read. Effective only to the total amount of payments actually received, period. I think this is me, but I don't think there's any doubt. This solves the problem of receipt and clearance of funds because it's not actually received until the funds clear. And otherwise, what this is saying is, I'm giving you a receipt for the money you've paid me and no more than that. This is however many dollars you give me, I waive my lien rights to that dollar amount, is all you're doing. If you haven't been paid on the change orders, you haven't waived those lien rights. If you haven't been paid on the retention, if you think this is too complicated, it is okay with me if you put a period after the word received, and it's going to solve 95% of your problems. The words after that are to deal with a very specific bankruptcy problem that is going to really irritate you if it ever happens. This is a true story. And there's been actually 2 or 3 bankruptcy court decisions on this, so there's no doubt this is the correct answer. We talked about preference cases before. One of the main defenses for preference cases is that I had mechanics lien rights. I would have filed a mechanics lien if you hadn't have given me that payment. So the poor, innocent material supplier received a check for $350,000. That's what it was, $340-something thousand. And it's cited, this case is cited in the book if you ever want to read it. If you're sick enough to think that's entertaining, you could read this bankruptcy court opinion. They received a check for $340-something thousand. The check bounced. But they exchanged the check for the lien waiver. Check bounced. And this is an example of what I said about consideration not working, now that I think about it. But, so there's histrionics, there's yelling, there's screaming. What happens? The debtor brings another check for $347,000. The check clears. Problem solved. No. They file bankruptcy 88 days later. 2 years after that, the trustee sues the paint guy for $347,000 preference they received 88 days before the debtor filed bankruptcy. Their lawyer said, wait a minute, that isn't right. I was a secured creditor. I had mechanics lien rights. Answer, incorrect. You had already waived your lien rights in exchange for the first check that bounced. At the time you received the second check that cleared, you were no longer a secured creditor. That's what the language after the word received is about. Or if you said upon receipt and clearance of funds, that would also do it.